Number 78, the people of the state of New York versus Stephen Myers. Counsel?
Good afternoon. May it please the court, John Sarando from Syracuse, New York, on behalf of the appellant Stephen Myers, and I'd like to reserve 2 minutes for rebuttal, if I may.
You may, sir.
Thank you. This is an appeal from a judgment of conviction for the crime of burglary in the third degree. Defendant was sentenced to serve 2 1/3 to 7 years after failing drug court. The issue we wish to bring before the court today concerns the adequacy of the waiver of the indictment.
I want to be clear. Your challenge isn't necessarily to the written waiver portion of it, but goes to whether or not there should have been some sort of colloquy between the court and the defendant.
Yes, Your Honor.
All right. And my question to you is, assuming that that has to be knowing, voluntarily, and intelligently made, that waiver, what is it that the defendant has to do to preserve that challenge, if anything?
Well, the appellate division indicated that it was not necessary to preserve the challenge. And
what's the rationale for that?
the rationale for that was, I believe they relied on the Boston case. And
that's the rationale that you're
Yes.
promoting here?
Yes, yes.
Okay. So, assuming that that's the case, how much does that allocution have to be?
How much
how
does the-
detailed? What is the court supposed to ask?
Well, in the analogy, the first part of the answer would be the analogy to the waiver of a jury trial, which, like this statute does not say anything about a colloquy in the statute itself, but the courts have indicated that in waiving a jury trial, the defendant has to knowingly, voluntarily, and intelligently realize what he's doing and agree to do that.
Can a court accept or reject a waiver of a jury trial?
Yes.
Okay. Can a court accept or reject a waiver of the right to indictment if the statutory and constitutional requirements are met?
Well, by constitutional requirement, I would add the voluntariness and the knowingly and the intelligent part. And I would say if that is
Well,
not met.
but you're arguing that the only way to ascertain whether the waiver is knowing, voluntary, and intelligent is to conduct a colloquy.
Yes.
Right? And the people are arguing, I believe, that the requirements of appearing with counsel and signing a detailed written waiver, and the requirements of which are in the statute, that all of that establishes that it's knowing, voluntary, and intelligent.
That,
Right?
the analogy I can bring is in the same sense as a waiver of a jury trial.
But my
there
point
has-
is that with the waiver of a jury trial, we don't have that whole statutory mechanism, and the court can decide for whatever reason, presumably because it's not knowing, voluntary, and intelligent, to reject a waiver. Whereas here, it seems to me that the way it's set up, because the court can't reject it, it's an acknowledgement that if those requirements are met, then it meets the knowing, voluntary, and intelligent test.
I don't think a silent record cannot presume a proper waiver. I think the court said
But the
this. and
record
people-
isn't silent. The record shows arguably again, that the waiver was signed in court as required with counsel, and that the waiver met all of the necessary requirements.
I would respectfully disagree that as to the waiver, that the record demonstrates that the waiver was actually signed in open court. There's nothing in the record to
So
verify that.
prior to the acceptance of the waiver, there's nothing here that indicates, there is later on during the plea colloquy, there's nothing that indicates that the defendant even could read or understand English or otherwise. I mean, he's obviously conversing with the judge in English. There's a very different issue about whether he can read and understand English.
Counsel, as I understand, your argument was twofold. One is what we've been talking about just now with Judge Stein, which is there's no indication on the record that there was compliance with the statutory requirements. Second, even if so, you still have to have this colloquy.
Right.
Is that correct?
Right.
What I'd like to understand is to part two, if we, let's assume that a waiver is validly executed, and we now put in a new requirement that you have to have some type of colloquy to elicit, to ensure that it's voluntary and knowing. What's the effect of that going to have on all the pleas, like your clients, where judges who weren't told they had to do this before, we're now faced with a number of pleas that were negotiated. We have plea agreements, we have guilty pleas, people who have served or are serving their sentences, and now they're going to be coming up through the pipeline. Let's assume they're live appeals, and they'll say, you know, you didn't engage in this colloquy. And now we have a requirement that you don't have to preserve, because we're saying no preservation is necessary, where we have thousands of pleas that are going to be affected by a rule that we put in.
Well, I don't know if the violation of constitutional rights should be tempered by such a concern initially, but
What do you make of the fact that the Constitution itself specifies a written waiver when it was amended? Is that part of the right, or is it at least something that we can assume that people who amended the Constitution believed was sufficient?
well, I still think to waive a constitutional right or to waive your rights, you have to do it knowingly, voluntarily, and intelligently. And I think that is the cloud that's over every.
So-
Why does that,
We have-
I'm sorry, you
I'm
go
sorry.
ahead.
So would it be enough if the judge just said, I see you've signed the waiver in the presence of your counsel, who's also signed the waiver. Did you have a chance to discuss it with your attorney? Is that enough?
That wouldn't be enough to have the defendant waive his right to appeal, so I don't think it is sufficient to have the defendant
So
waive
is
the
part of
right.
your argument that because this is of a constitutional dimension, we should certainly not have a lesser requirement than we have for the violation, for the waiver of a statutory right to appeal?
Right, yes.
Okay.
Yes, Your Honor.
But to go back to Judge Wilson's question, let's assume that the state constitution, the drafters intended this to be a knowing, intelligent, and voluntary waiver. This would satisfy that, this written form. We would essentially be saying our constitution falls below the federal floor. That would have to be our finding, right? But the state, it would be kind of the reverse of our usual state
Usually
constitution jurisprudence.
it's the other way around.
But we would have to say this violates the Constitution of the
think
United States.
Even in the federal statute, federal constitution, you still have to have it knowingly, voluntarily,
But
and
assume that
intelligently.
our state constitution doesn't require that we've said in the state constitution that this extensive written waiver is sufficient. To find that isn't, we'd have to say essentially our state constitutional provision doesn't meet the federal constitutional
Basic-
standard.
Well, I think we're talking about, what is this, a personal right which the defendant can waive, and if the defendant's waiving a personal right, such a personal right has to be done knowingly, voluntarily, and intelligently, and I would fall back on that analysis, Your Honor.
I guess I struggle with the idea that the only way that this can be done is by an oral waiver of some form, a detailed oral waiver. Because if I'm correct, you're saying that the procedure that's used to waive the right of appeal would be insufficient.
No, I didn't mean it that way.
Okay.
I meant
Explain that to
in
me.
response to Judge Feinman's question, that what he proposed was not sufficient to waive someone's right to appeal, so it shouldn't be sufficient to
I see.
waive indictment.
I
That was
see.
the analysis I gave.
So why do we need an oral waiver on top of the written waiver? Because that's in essence what you're asking.
For the same reason we need it in a jury waiver for the same reason we need it in a appeal waiver,
And that reason is what?
that we want to ensure that a waiver of a constitutional right is knowingly, voluntarily, and intelligently entered.
I see.
Well, counsel, just to clarify, your argument is not that every item that might be included in the written waiver has to be part of the colloquy. Are
No,
you- No.
no.
I thought your argument was that the court, as it has to for other types of rights, has to be convinced that the individual is knowingly and intelligently waiving the right.
Right.
That could mean something as simple as asking, did
know
you
your-
read it, and do you know what it means?
Right.
And did you discuss that with your lawyer?
Right, or simply stating, do you know your case can be presented to the grand jury where you have the opportunity to testify? And if that takes place, the court then can have the opportunity to determine if the evidence before the grand jury is sufficient and if the procedures were followed. Do you understand that? And do you wish to waive those rights and enter a plea of guilty to burglary in the third degree in accordance with this plea bargain? And then if he says yes, then you have him sign the waiver. You acknowledge your signature, pass it up to the judge, he signs it. Then you go into talking about his plea bargain, and then waiver of his right to appeal, separate, which I think this court is required. And then I would say that the procedures and Judge Jason's dissent in Sizemore would have been met. Thank you.
Thank you, counsel. Counsel?
Well, Your Honors, Nicole Inshert for the people of the state of New York. If I could, I guess I would like to start with the question about preservation. I believe that the second contention here that we're concerned about, the requirement of an oral colloquy, is improperly before this court. Inasmuch as I think the court is in agreement, it's something above and beyond what is being required.
I haven't agreed to anything yet. I just asked questions.
My mistake.
Well, how
I
is it
apologize.
unpreserved? Isn't it clear that what he's saying is that what went on here didn't comply with the Constitution? And haven't we said, if that's your claim, that that doesn't require preservation?
And if this court were to find that, in fact, the lack of a colloquy did not comply with the Constitution, then it would, I submit, be a mode of proceedings error that wouldn't require preservation. But I don't think that, based on what is in the Constitution, what is under the statute right now, that the oral colloquy is required, and I would ask the
This is
court
one
to
of those strange
consider.
situations where we have to decide that first to decide whether it needs to be preserved or not, right?
Agreed, Your Honor, yes. And I think that former presiding Justice Kaye's reasoning in People v. Page is instructive. In People v. Page, of course, we were considering the waiver of the right to trial by jury, and considering much, I think, the same issues here. There, the waiver of a right to trial by jury was attempted to be effected orally, and the case came all the way up before this court, and the discussion was whether the oral colloquy would suffice without a written colloquy, and a written waiver. And the written waiver is what is and was required under the Constitution and under the CPL. And Judge Kaye, as I think astutely, pointed out that that is what the drafters of the Constitution and what the people of the state of New York through the legislature decided was
But
necessary.
that's not the question, because the statute, the Constitution says, such waiver shall be evinced by written instrument. But his question, or the issue he's posing, is how does the court know that the waiver is knowingly and intelligently given? It's not whether or not there's a writing. It could not possibly be, but you'll correct me otherwise, the people's position that if the defendant either didn't speak English, and the waiver is only written in English, or the defendant couldn't read, that the simple fact that they signed that waiver with their name means that they understood the waiver. Don't you need the judge to ask something?
Well, I would say that there needs to be some sort of indication that there's an understanding, at a minimum, of whether the defendant can read and write. And
So how do we have that, so accepting that concession, how do you have that evidence on this record?
it's a little bit out of
Before
order.
you get to the plea colloquy?
Admittedly, I'm not sure that my recollection of the record is all that clear, but based on my recollection, the court did not address the defendant himself before we entered the waiver of indictment. But I do think it's notable and instructive that immediately thereafter, we went right into taking the plea, and in the course of taking the plea, those sorts of questions were asked and answered. And if at some point during the colloquy on the plea, how old are you, do you speak and read and understand English? Have you had sufficient time to confer with your attorney? Are you under the influence of any drugs or alcohol, et cetera, et cetera? If there had been some sort of issue there, then I think we would have readily been aware that there was an issue with the waiver of
So
indictment.
since we're looking at a statewide rule, if those questions had not had been asked and you didn't have those answers, because you make, of course, an excellent point, how then does the judge know that the waiver is valid and knowing and intelligent?
I'm afraid I don't have a good answer, other than it would seem that in other cases where we're looking at the waiver of the right to a trial by jury, the entry of the plea, the entry of the waiver of the right to trial by jury was found acceptable, even though there wasn't an oral colloquy that accompanied it. And I apologize because these cases weren't in my brief, but there are a handful of cases from the various departments of the appellate division saying that looking at the other circumstances surrounding the entry of the waiver of the right to trial by jury, it could be inferred that despite the lack of a colloquy, the entry was knowing, voluntarily, and intelligently done.
So I just want to address a concern that I think was raised by Judge Garcia. It's not your experience, is it, that there are literally hundreds of thousands of pleas that could now be attacked based on the failure to have any colloquy? I mean, it would be more likely that most judges have asked something. You know, maybe here just the judge forgot to do that.
I am inclined to believe that in this particular instance, this was a one-time mistake that I think the judge got distracted while he was at the bench and forgot to engage in the colloquy that would have been his normal practice.
Right. So are you familiar at all with the sample colloquy that's up there with the PJI charges?
I've reviewed the model colloquy, Your Honor.
On the NewYorkCourts.gov website. Are you
Yes, Your
familiar with
Honor.
that? All right. So is everything that's in that sample colloquy required, or is it something less?
I would submit that it's something less, if I may refer.
Yeah, sure. Yeah, yeah.
Well, haven't we generally with these types of colloquies said that there's no specific
Catechism?
Catechism, yeah.
Sorry, Your Honor, I didn't mean
No,
to speak for you.
that's
But
okay.
I agree, and so I can't, I certainly don't want to be responsible for scripting what the colloquy should be. And I just think that there's,
But the conscientious judge, being aware of this script, would be on notice, even if we have never opined on this, that such a colloquy makes sense to confirm that the individual knows what they're doing?
I'm sure that judges are aware, and I'm sure that it does make sense. I'm not at all saying that a colloquy is, an oral colloquy in addition to the written waiver is a bad idea. It's just that I don't think under the structure that we have that it's necessary for there to be a specific one or
But the
one at all.
waiver at that point goes to the very jurisdiction of the court, right? Because this is happening in some sort of, whether it's a Supreme Court part on what is up till that point, a pending felony complaint,
Correct,
for
Judge.
which the Supreme Court or the county court would have no jurisdiction otherwise, right?
Right.
That would be still pending in the lower local criminal court, whether that's the criminal court of the city of New York or some other local court, right?
Right.
So until you get jurisdiction through the waiver, how can you cure it with the plea part? I'm going back to something you said earlier. I mean, don't you really need it
Question is,
up
can you
front?
do a totality of the circumstances type analysis here?
And I think that you can, in the sense that I believe that's the sort of suggested review that has come up through the third, fourth, and I believe the second department.
Well, the point is, it's a status question. The status doesn't change from moments before to moments later. Either the person knows English and can read, or they can't.
That's correct, Judge.
Going back to some questions about the effect of this, so aside from pleas in the pipeline, so to speak, would this have any effect, for example, on predicate felony determinations?
Truthfully, Your Honor, I'm not sure that I know the answer to that question. I'm not sure I can give the court an adequate answer to that question. It certainly seems like it would implicate in the lines of like a CAT-2 sort of analysis, which, as far as I'm aware, could lead to the implication that we have all these kind of procedural nightmares to go back and fix or address one way or another. But beyond that, I'm afraid I
But
don't
aren't
have
we
an answer.
really, wouldn't it really boil down to an ineffective assistance of counsel claim? Counsel should have raised it, they didn't. We've never opined on it, so maybe you don't have the kind of Turner claim anyway. When we're really talking about prospectively, not retrospectively.
Your Honor, I'm sorry, I don't know the answer. I would be happy to get back to you if
Fair enough.
the court would like an additional submission on that particular issue.
Thank you, counsel.
All right, thank you, Your Honors.
Counsel?
I think Judge Garcia, rather than looking back, looking forward, it's my understanding that now our largest county in the state, New York County, is going to start utilizing Superior Court informations in an effort to speedily dispose of matters.
But there have been SCI pleas in all the counties of the city for years. You have Part F and you have the N part, the narcotics part. So I mean, the judges there are familiar with those waivers. So, but it's been done in all the counties of the city of New York. But the real concern, I think, that Judge Garcia was expressing is, are we now creating a rule that retrospectively, if we adopt your position, endangers literally thousands of otherwise settled pleas?
I don't believe so, Your Honor, because I don't think there's that many cases in the state where there's absolutely no colloquy at all. And that's what we have
We're
here.
going to be setting some kind of a floor, and I know we always say there's no catechism for this.
Right.
But then it will be, did this meet the non-catechism test? Did this meet, did you just say, did you execute this extensive written waiver? Is that enough? And we've never said there is any requirement yet.
Right.
So a judge who doesn't follow a form or who accepts this in-court written waiver in the presence of counsel and thinks that's entirely appropriate because we've never said otherwise, and that case is live. Forget collateral attacks and ineffective assistance. There are thousands of these cases, I would imagine, plea cases in the pipeline right now. There's no preservation requirement if we find this. And so we are going to start to get, and other cases like this come to mind, all these live cases first that say, we didn't have to preserve this error. There was nothing at all, no catechism, nothing, or this was this. It didn't meet even your minimal standard. And we are going to be reviewing, or the appellate divisions are going to be reviewing thousands of these cases based on a new rule.
Didn't you have that same problem when the court said that the guilty pleas were improper for certain reasons?
We
Didn't we
did.
have that same problem when the court said that the notice or the waiver of appeal can't just be done with a form? And more importantly, I think it was in answer to Judge Feynman's question where you said, looking at what happened subsequently during the proceedings to use it prospectively, I don't think that would fly in the face of this court saying that the guilty plea is a separate entity and has to be resolved. The waiver of appeal is a separate entity, separate and distinct, and has to be resolved. They can't be lumped together, and I don't think the
Well,
waiver...
here, I mean, the argument would be that you can't do that because until such time that you get the valid waiver, the court doesn't, the Supreme Court or the county court, depending on what jurisdiction you're in, doesn't even have jurisdiction.
Right, and that's why we don't need to preserve it. Thank you.
Thank you,
Thank you.
counsel.